Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources. I'm Kerry Fink with Helping Seniors Television. Thank you for joining us today. I have the privilege of sitting in for our president and founder, Joe Steckler. And what an exciting show that we have that's going to be not only informational, but probably very valuable economically because of the things that we're going to talk about to you today. I'm really privileged to have with us in the Helping Seniors TV studio today, Ruth Rhodes, who is an elder law attorney with Rhodes Law P.A. and also a board member who graciously volunteers her time to help us in the work of helping seniors. Welcome today.
Thank you, Kerry. Thank you for having me.
Appreciate you being here. And we're talking about you and Joe together did some marvelous television shows. You know, viewer, the TV shows that we've done, and it's been over 250 now television shows that between Joe Steckler and Helping Seniors we've created over the time that Helping Seniors has been around. We're now entering our I think it's our 10th year of service now that we're moving into for Helping Seniors, and 250 programs that are still valuable and of informational, value to you as you make your own aging plan. And you did a phenomenal show with Joe a couple of years ago that we get a lot of requests and a lot of views on about bankruptcy for seniors. And you brought to light the fact that this is something that seniors hit a lot. And you said as your firm has grown, you've really started to focus on elder law practices and things, but of course you bring all that expertise of financial matters as well.
Yes, yes. It's very helpful to have that background, especially in the elder arena, because I can help with asset protection, and that's still very important, and it's still something as an elder law attorney that I do. Yeah,
you know, I think it was, to me, it was quite, I guess, revelational to understand that seniors in particular, especially because most grew up in a generation where they feel like, well, I need to meet my obligations, but then they hit some overwhelming medical things or different things and are just really caught in a rock and a hard place. And I guess a lot of times one of the things that Joe talks about is that's why it's so important to get an aging plan together, is to help you maneuver the pitfalls that you might otherwise run into. And so I guess as an elder law attorney, probably I would think maybe your first point of advice would be come in and sit down and let's go through what you have so we can make sure you're protected the right way.
Yeah, that's absolutely right. So the first thing I want to do when I speak to a new client is I do want to make sure that they have a plan for themselves, that they have a plan in case they lose capacity, and if they have special needs in the family, maybe a child that's disabled or grandchild, that they have a plan set up for that child. And I also want to make sure that they have a plan for what happens after they're no longer in the picture.
Yeah, it seems so important, and so often we talk about things like guardianships and things like that come up simply because oftentimes if that paperwork wasn't created the right way, it can cause all sorts of problems downstream.
Very right. Yes, that's very true.
So today on the program, though, we're going to do a topic that we have never actually done and devoted a program to before, and we're going to talk about probate. Now, I know a lot of times we're always taught, well, the reason you want to do your pre-planning and get everything organized is so that you can avoid probate. But you brought up the point that sometimes probate can have certain advantages, so it's not maybe as cut and dried as I might have first thought. So let me just start with the question, what is probate?
Okay. Well, probate is a legal process, and it goes through the court. It's court supervised, and the process involves determining who the heirs are going to be of your estate, gathering your assets together, having a system for paying any creditors you may have, and distributing assets if there's any money left over after creditors are taken care of.
And so when we talk about that, we're always told, well, we should avoid probate. And why is that?
Well, probate is time consuming, and it can be expensive and time consuming because if you file a probate, it's generally going to take anywhere between 9 months and a year for an uncontested probate. and it becomes expensive because most probates are going to require an attorney to assist. And of course, the attorney has to be paid.
Right.
And so that's a fee that can quickly add up. Fortunately, the Florida statutes does set out a schedule of what is presumed to be a reasonable fee, and it's approximately 3% of the estate.
Okay. Okay.
But if you have a large estate, that can be a significant payday for the attorneys. So to save money for the estate and make sure more money goes to the beneficiaries, some folks want to make sure they avoid probate.
Now, you said that there are different types of probate. So it's not for the person that just comes into it and you say, you know, we hear this term about avoiding probate, and for us, we just think there's one probate, but you actually said there's several different kinds we want to think about.
Yes. In Florida, there's 3 different types of probate. There's the disposition without administration. That's the most simple. And that one is not very often used. It's strictly for when a person has paid the funeral bills and that person wants to be reimbursed. And it has to be done within certain confines. It's generally going to be no real estate involved. And the non-exempt personal property of the decedent cannot exceed the amount of the last expenses. It could be the funeral expenses or the last hospital expenses. It's usually not used, and it doesn't require an attorney. So I don't do those in my office. So I'm not super familiar with the process. I do know that it's supposed to be simple. The other more common is summary administration. That's going to be for a smaller estate of less than $75,000 of non-exempt assets, and no attorney is required for that one either. However, it's still complex, so I still will occasionally have folks come in and hire me to help with the summary administration. However, even if they have a small estate, less than $75,000, if they have an asset that requires letters of administration, then summary administration won't work. They'll have to do a formal administration. And formal administration is required when you have an estate of more than $75,000. Or when there's a situation where you need to have letters of administration issued. An example of that that I've come across more than once is where we have a life insurance policy and the decedent failed to put a designated beneficiary on the life insurance policy, or the person that they did designate as a beneficiary has died before them. So now the money has to go to the estate. And I've come across this several times with life insurance companies where they won't release the money unless there is a personal representative appointed and there's letters of administration. Letters of administration is just a piece of paper from the court saying this person has authority to act on behalf.
That's what I was going to ask you. What is that? Because, you know, I was joking in a recent show. I said, you know, we live on the Space Coast, so we have NASA here, and we're used to acronyms and short things. But so letters of administration is a designation of a person who can handle affairs for the estate.
Yes, that is the person who the court has appointed. So in a will, you can name who you would prefer. And as long as they meet the requirements to be a personal representative, that's what we call them in Florida. Some states call them executors, but they're the same thing. As long as they meet the requirements to be a personal representative, and then the court will appoint them and issue letters of administration, and then we get them certified copies of that document, and they'll take it to the bank or send it to the insurance company, and that's their official paperwork that lets them do that work.
So now that we've talked about types of probate, let's talk a little bit about, because I guess the one that we really focus in is that what you described, the formal administration, where there is enough things that you have to move to that level. But then let's talk about, because you said not all assets require probate. And so there's a whole discussion about types of assets that maybe aren't involved in that.
Oh, yes. There are a lot of assets that don't require probate. For example, if you own real estate with another person, it doesn't have to be your spouse. It could be, though. And you own that piece of real estate as joint tenants with rights of survivorship. That's a very special way of owning it. Then when one joint owner dies, the other joint owner automatically, by operation of law, becomes the owner.
Okay.
And the only thing really with real estate in particular that survivor has to do to show that they are the sole owner now is have a copy of the death certificate recorded in the public records.
Okay.
So it's an easy process. Another example would be when you have joint owners on a bank account.
Okay.
Like usually that's a husband and wife, or sometimes it's a child and a parent, and they are joint owners. And when one joint owner passes, the remaining surviving joint owner becomes the owner of the account. All they have to do is bring the death certificate, usually to the bank, to show that.
Right.
Another type of asset that doesn't require probate would be like a payable on death account or transfer on death account. Sometimes it's called a POD or TOD. Those are designations that you do with the bank itself, where you say, upon my passing, I want whatever is in this account to go to this person or a couple of people, or you can even divide it up different percentages. But that person who you name to get the money after you pass, they don't have access to the funds while you're alive. And if it's a jointly owned account, that person won't have access to the funds until both owners have passed.
Right.
So that's a good vehicle to use to avoid probate for bank accounts. The only thing that I always want to talk to my clients about when it comes to TOD accounts or POD accounts are going to be, are there any reasons why you wouldn't want that person to actually get all that money all at one time? So does that person, him or herself, have creditor problems? Because we wouldn't want the money to go from that you wanted to leave to your child to end up in your child's ex-spouse's hands.
Sure.
Or maybe they owe Visa card. You don't want it to go to that. You want to be able to protect it. So maybe that's not the best way to do it.
Interesting.
You know, maybe there's another way that we need to think about it.
Well, that was a point that you brought up actually as we were just discussing the topic before the camera was rolling. You said, you know, surprisingly, there might be certain circumstances where probate could actually be helpful. And I wanted to just ask, that was an interesting point you just brought up about that you want to think through those kind of things, that you might be wanting to do something with a good intention to help your son or your daughter or whatever the case may be, but then there may be some extenuating circumstances that may cause that, you know, an unintended consequence of you're trying to be a nice person.
Well, right. And you wouldn't want the money that you saved and scrimped over for your lifetime to end up in the hands of a stranger.
Right, right.
So one of the things that we can do in probate, one of the advantages of probate, would be if the person who passed away, who we refer to as the decedent, if that person has creditor problems, you can use probate to shorten the amount of time that the creditors can go after the estate for money. So there is a statute of limitations already in place that there's a 2-year max. From the date of death, the creditor only has 2 years to go after the estate for money owed. You can shorten that with probate. You can shorten it up to 30 days. If you know the creditor exists, sometimes you don't always know. Sometimes the person who steps in to take care of the estate doesn't know all the creditors. But if they do know, then we're going to want to serve that creditor directly, and then that starts a 30-day clock. And they have 30 days to file a claim, and then with the estate, and there's requirements, specific requirements. If they don't follow it precisely, they're out. And then there's other creditors that maybe you don't know about. Right. That's when we publish in the paper, in the newspaper, a notice to creditors, letting creditors know that a probate's been filed and they have a certain amount of time to make a claim. That's a 90-day period. So we have a little strategy that we use because the creditors that are known can have either the 30 days or the 90 days, whatever the maximum is. So we want to shorten the ones that we know about. So what we'll do is our strategy, and I'm probably giving away one of my little secrets, is we'll do a publication in the paper for the notice of creditors, We'll get that 90 days started. And at about the 45th or 50th day, I'll get ready to serve the known creditors.
Okay.
So that when the 90-day runs out, it runs out at about the same time that the 30-day runs out, and then that's done.
Right. Well, that's particularly useful because let's say you are a son or a daughter and you're the person that mom or dad wanted you to take a look at, but maybe you're out of town and you don't really know everything that's going on. And even if you're trying to be diligent, something may pop up way down the road and you just didn't have any clue if it's legitimate or what it was.
Right. So that person, if they're the person that's going to be in charge of the estate, they do have to do due diligence when they investigate. And part of the due diligence that I suggest is looking back at mom and dad's bank records for up to a year, because some bills you pay monthly, some quarterly, some annually.
Sure.
So we'll say go back a year, check the tax returns, have the mail forwarded.
Right.
So any known creditors that are still billing actively, you'll get that mail.
You would see that, right.
Yeah. And you just do your best. I mean, sometimes you have to be a real sleuth sometimes.
Sure.
But that's why we have that publication. Because
Okay.
after you do your due diligence and you serve all the known creditors, reasonably ascertainable creditors,
Right.
then the unknown ones, you're doing the publication.
Right. Well, it makes sense. Now, let's shift gears and talk for a minute about how to avoid probate. We'd written that down as a topic that we should cover. And you said there was actually a couple of different things that could be useful in that.
Yes. Okay. So part of the estate planning process is if it's one of the goals to avoid probate, then I will look at the types of assets that the client has and try to determine what's the best way to avoid probate and what is their goals too.
Sure.
If they own real estate or if they have a person that they want to leave some money to that has special needs, then maybe a trust is the way to go. But I talked to the client about that. But what a trust is, and it's not just for rich people. I know a lot of people think, I'm poor, I don't really need a trust. But you don't have to be rich to have a trust, and trusts don't have to be complicated. Okay. It's a simple paper document where you are naming the person who's going to be a beneficiary. The person who drafts and creates the trust is usually called the settlor of the trust or the grantor of the trust. That's the creator. Then they have a beneficiary of who's going to benefit from whatever assets you put into the trust. And then you have a trustee. And the trustee is the person who will own title to whatever assets you put into the trust. And they have duties to protect the assets and take care of the assets, and they owe those duties to not only the settlor or grantor of the trust who created the trust, but also to the beneficiary. Usually when you first create a trust, that's all one person. You are the grantor or settlor of your trust, you are the first beneficiary, and you are your trustee. Okay. And so we use a trust for not only avoiding probate, because the trust can distribute assets without having to go through probate, and it can be very private, right? Because the trustee owns the title. Okay. So we don't need the court to say, okay, you can transfer title. Because right? So with real estate, if it's not in a trust and there's no other avenue for transferring title to the next person, probate's required to transfer title. Okay. But a trust can do it without probate. Another thing that a trust does that kind of works double time for you is it can be used to avoid guardianship too. So it could be a really great tool for that as well. So that's one way of avoiding probate. But I also talk to the client about how they own assets, what kind of assets, how they own it, and what their ideas are for leaving it. And maybe we'll talk about joint ownership. Okay. Maybe we'll talk about, especially with real estate, maybe a enhanced life estate deed, which that's another special way for you to transfer ownership upon your passing without having to go through probate.
Okay, so you said that was called an
enhanced life estate deed. Sometimes it's called a ladybird deed. Sometimes it's called that.
I've heard that term, but I don't think I understand exactly what that means.
So what it is, and not all states have this. I found out by talking to attorneys from different states. Not all of them have this, but Florida does. It is a special deed where you, as the owner, can reserve a life estate for yourself and your property, and then upon your passing, it goes to your remaindermen, which could be your children or whoever you want to take ownership upon your passing.
Okay.
And the reason why it's called enhanced is because you still have the right to kind of revoke that.
Change your mind.
Yes. So you can still like mortgage it or sell it and not owe any duties to your remainderment.
Okay.
Under a regular life estate deed, that is not the situation.
Uh-huh.
And I have had cases where mom or dad have gotten a regular life estate deed and with the remainder to their children and then decide, I want to sell my house. Then they have to ask their children for permission. And I've actually had the case where the children has denied permission and we had to sue the children.
Oh my goodness.
Yeah, so it can be pretty nasty. I don't recommend all, willy-nilly adding people to deeds. I think it's a terrible idea and it needs to be carefully thought out.
Mm-hmm. Well, there's so many things that you talk about. I guess one of the things is probably a good moment to just stop down for a minute and say, this is really where the value of having a good consultation with an attorney that's expert in this, like yourself, could really make all the difference, because it sounds like there's so many potential pitfalls or things that you might make a multi $10,000, $20,000 kind of mistake simply because you didn't know the difference between just what you were talking about, an enhanced life versus a life trust kind of situation. So it really makes sense. How would you recommend somebody that may be viewing this program and saying, okay, I'm hearing all this discussion, what would you tell them that the correct step to do? Is it that they sit down and have a consultation, or what would you tell them if you're interested in this topic and maximizing your results with what you're trying to do? What would you say they do? Well,
I would highly recommend that they consult with an attorney who regularly practices in estate planning, because it is a specialty or a very special area. And I have seen where people have consulted with attorneys that don't necessarily focus on estate planning and have had problems.
Right. It seems like you want the right specialist for what you're going to talk about.
Right. You would want to make sure you speak to either an elder law attorney or an estate planning attorney or someone who works in that area of the law regularly.
Now, it's interesting because you were talking about that in your own firm, particularly you guys have been growing like crazy, but you said it has been, that is really an area of specialty for you now, is concentrating on that side of it, the elder law side of it.
Yes.
How do people get in touch with you, and how does it work if they want to get information from your office in particular?
There's several different ways.
Okay.
You can email me at my email address. Do you want me to give it?
Yeah, please.
Okay. My personal email address is Ruth at Rhodes Law P.A.com. I'll spell it.
Yeah.
It's Ruth, R-U-T-H, at Rhodes, RHODESLAW.PA.com. I have a website, RhodesLawPA.com.
Okay.
Or you can call the office at 321-610-4542. And we always meet, most of our clients that come to us get a free consultation for most of the practice areas that I practice in. So if it's an estate planning, avoiding probate issue, that is a free consultation. And
it sure would seem like, I'm going to ask you to say the phone number one more time, so go ahead and grab a pencil so you can jot this down. But it seems like if it's not going to cost you to have the advice or at least get kind of a read on the situation, it would seem like it would be terribly remiss to not take advantage of that, so that you would just know, like, here's the idea of here's what would be recommended, because it has to be impossible because everybody has such a variance in terms of what they have to work with and what their concerns are. That you can't just generalize. You would have to sit down with somebody.
That is very true. I can give general information, but when it comes to what do you do with your plan, that requires a one-on-one talking, conference. Yeah. And what my goal is as an elder law attorney is I want to educate. Here's the options. Here's the good, the bad, the ugly, and then you decide what you want to do, and then I take my direction from you. If I feel like your direction's a little off, I'll let you know. This is what I think. But ultimately, I work for my client, and so I'll do what they want me to do. I'll tell them the good, the bad, and the ugly on what they're doing, and then ultimately it's their decision.
Well, and let me go ahead, because I asked you to get a pencil. Give that phone number one more time.
Okay, it's 321-610-4542.
And you really want to take advantage of an opportunity, because it doesn't cost to be able to gather your material together and get some solid direction and ideas about what would be appropriate for your situation. Because it seems like, on the flip side, by not doing that, you run into certain things that the law will make decisions for you that you may not have intended.
That is very correct. If you don't have proper documentation in place, and say you have an unfortunate event with your health, or you get in an accident and you need someone to be able to make decisions for you, maybe pay your bills or talk to insurance companies or things like that. If you don't have a good, durable power of attorney, then a guardianship may be needed.
Right.
And to me, that is one of the worst things that to have to go through, because it is so expensive, and it can be avoided most of the time.
So a little bit, this is a case where a little bit of advanced planning can really make the difference. So again, Ruth, I want to thank you for joining us on the TV program today. I want to encourage you, viewer, to take a look at all the resources that are available on the Helping Seniors website and on the Helping Seniors YouTube channel. As I mentioned at the open of the program, there's a great program, a couple of great programs actually, that I think Joe did with Ruth, talking about some areas that you want to think about financially. But this Today program is a great one to think about in terms of probate. So thank you, Ruth, for joining us, and thank you, viewer, for joining us on Helping Seniors TV.
Joe Steckler, thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.